So, good morning again. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and I'm here to talk to you about the Connecticut Paid Leave Program. We're also going to talk a little bit about FMLA, just to make sure that everyone has a clear understanding of how the two separate programs are similar, how they're different, and how they interact. So we'll talk about the authority, which is where I work, and then we'll talk about the definitions of FMLA and CTPL. We'll go through sort of what the reasons are when I talk about qualifying reasons for leave and for benefits, and then we'll really get into the specifics of what do you as a worker need to know. The Paid Leave Authority is a quasi-public agency, which means we're a public entity. We're a creature of the state and created by statute to create a program that allows workers the opportunity to receive income replacement benefits when they can't work because they're sick, or they have to care for a family member, or other qualifying reasons. Basically, the idea is to recognize people are put into impossible decisions every day where they have to figure out, can I take the time off to be with my loved one, and if I need to do that, how do I make sure I keep food on the table and a roof over my head? And so we were created to help bridge that gap, to provide workers with access to income replacement benefits, and equally as importantly, to make sure that everybody else involved, the employers, the healthcare providers, administrators, understand their roles so that the process can work as seamlessly as possible. As an authority, we wear a lot of hats. We do a lot of outreach and education, like webinars like this. So thank you for coming this morning. We also had to create the authority. We're brand new, completely independent. So we had to set ourselves up as a quasi-public agency. We don't have regulations. We have publicly noticed and board adopted policies. So we've been working on those. Of course, we receive the contributions that are sent to us. And in the future, if the trust fund becomes nice and healthy, we may be able to reduce the amount that workers contribute. There is a process that allows employers to say, we offer as good or better benefits to our employees, and please let us use that process instead of your public program. So employers apply to us for that alternate compliance method. We review the proposed self-insured plan or insured plan, and we will be auditing those companies. And the big thing is administering claims for paid leave benefits. Now, the Connecticut Paid Leave Program is unique in that our program is entirely employee funded. In other states, there's an employee-employer contribution, which has some positives and some negatives, but the best thing about being entirely employee funded is that the entitlement moves with the employee. It doesn't really matter which particular job you have right now. If you've been working for covered employers, and kind of maintain your access to our program. So as I said, the employees contribute, and the contribution is 0.5% of your wages. And we calculate wages the same way that wages are calculated for purposes of your FICA obligation. And the reason we use that FICA number, which means that we don't count things like a qualified employer benefit plan toward your wages, is that the contributions are capped at the Social Security contribution limit. And so we need to use the same definition that the Social Security contribution limit uses. What happens is the employee is responsible for the funding, but in reality, the employer is the one who's handling the paychecks. So the employer deducts the 0.5% from the wages and then remits them to us on a quarterly basis. I'm seeing a note that says you can see my screen, so that's a good thing. So the employers remit those contributions to us on a quarterly basis with some very basic wage information, which we validate. The money goes into the Paid Leave Trust, which is administered by the Office of the State Treasurer. But the Paid Leave Trust is not state money. It cannot be used for any purposes other than to fund the benefits and administer the program. It can't be swept for any other purpose or used for any other goal or state program. A couple key things to note. Hopefully this contribution concept is not new to you because the contributions began in January. So your employer should have started taking deductions from your paychecks in January. We did allow for a grace period. We knew that some employers weren't quite ready to do the deductions right away. And so there was a grace period where the contribution might have been a little bit more than 0.5% because they were just catching up from missing some of those first few months. The grace period is now over, by the way. So you should be seeing just 0.5% out of your wages. Starting last week, just December 1st, we allowed people to start submitting applications for benefits. Now, the program doesn't officially take effect until January 1st, so we can't pay any benefits until January. And the benefits are related to absences that are happening in January or after. But we knew that there were people who knew they were going to be out. And so we wanted to let people apply early. And so that process is now open. All right, that's a nice little overview, but let's get into the basics here. What is FMLA and what is CTPL? Well, FMLA stands for Family and Medical Leave Act. When I'm not being precise, I just say FMLA, but there's actually a federal FMLA and a Connecticut FMLA. Both of these laws have been around since the 90s, so you may be familiar with them. Both laws allow eligible employees to take job-protected time off from work for specific reasons. And both laws say that leave taken under FMLA is unpaid. So the entitlement is just the job protection. They say that the employers may adopt policies to provide their employees with income replacement during leave, but they're not required to do so. Some employers have adopted policies that just provide paid leave. Maybe they just keep them on the employee's salary for a period of time. We often see that with parental leave for some reason. That's like the big one. I think more frequently you see employers allow or require the employees to use their earned accruals. So vacation time, sick leave, other PTO, while they're out on leave. So that it's an unpaid leave, but you could substitute in your vacation to make sure you still get money coming in. The federal FMLA has been in the news a lot, but there have been no changes to the federal FMLA, and it doesn't look like we're going to see a federal paid leave program anytime soon. The Connecticut FMLA was amended by a public act in 2019, but those changes did not take effect right away. Those changes will take effect starting January 1st, 2022. And I'll talk about those changes in a minute. Then there's CTPL. So CTPL is the acronym we use to refer to Connecticut Paid Leave. Again, we sometimes just talk about Connecticut Paid Leave when we're talking about the statute. More often we talk about it with the program. Some people talk about it, use CTPL to refer to us. Usually we talk about ourselves as the Paid Leave Authority. The thing to know about Connecticut Paid Leave is that it is a source of income replacement benefits. It does not provide any job protected leave. This is not a separate or additional source of time off from work. This is a source of money if you're out of work for a qualifying reason. You may hear people talk about it as PFML or PFML, which I hate, but people do, or paid family medical leave. That's fine. It all means the same thing, but focus on the fact that it's paid, right? That's what we do. We provide the money. So for both FMLA and Connecticut Paid Leave, you have to be out of work for a qualifying reason to either apply for leave and have that job protection or receive the income replacement benefits from us. And the qualifying reasons are pretty similar. First, there's the medical leave. That's leave that you need to take to receive treatment or recover from your own serious health condition. And the definition of serious health condition includes things like an overnight stay at the hospital, something we call incapacity plus treatment, or a chronic condition that requires you to have treatment. It could be an end of life situation where maybe there's no treatment, but there's palliative care. It also includes serving as an organ or bone marrow donor, as well as pregnancy. Then there's bonding leave. So bonding is when you have that time to create that emotional and physical attachment between the baby and the parent. You can take bonding leave to care for a child who was born to you, or a child who's been placed with your family through adoption or foster care. And it bears repeating that both parents can take bonding leave, but only the parents take bonding leave. The whole family's excited about the baby, but only the parents are the ones who are taking bonding leave. Then there's caregiver leave. Caregiver leave is the leave you take if your family member has a serious health condition and you need to help take care of them. Now, taking care of them could mean taking them to the doctor. It could mean helping them with their physical therapy. It could just be being with them. We call it providing psychological care and comfort. So that sort of time spent with the person who's sick. There's a special kind of caregiver leave called military caregiver leave. That's leave taken by a worker to care for a covered family member who was injured in the line of duty on active duty in the armed services. And the reason it's separate and designated as a separate type of leave is that you actually get more time. It's up to 26 weeks of leave in a 12-month period per family member per injury. So there's sort of a recognition by the legislature that we need to provide this extra support to family members of people who are injured in the line of duty in the service. There's also something called qualifying exigency leave, which is also available to family members of military service members. You take qualifying exigency leave if your parent, spouse, or child has been called to federal active duty or is deployed on federal active duty. Then separately, there's something called the Family Violence Leave Act. This is a Connecticut statute. It's been on the books for over a decade. And it says that a covered employee may take unpaid time off from work up to 12 days in a calendar year if they're a victim of family violence and they need the time to receive psychological care or medical care associated with the violence, to obtain services from a victim service organization, to relocate if they need to because of the family violence, or to participate in a civil or criminal proceeding relating to that family violence. So it's not technically FMLA, but it is another reason that an employee may have job-protected time off from work. And if they're taking that family violence leave, they can receive income replacement benefits from the authority. So that's why we talk about it here. Now, as I mentioned, there's the federal FMLA and the Connecticut FMLA. And there are lots of similarities in terms of the reasons that you can take federal FMLA versus Connecticut FMLA. But there's one huge difference, and that is the definition of family member. Under federal FMLA, and frankly, under Connecticut FMLA until it changes on January 1st, an employee can take leave to care for a parent, spouse, or a child who's under 18 or 18 and over who has a disability as defined by the ADA, the Americans with Disabilities Act, which prevents that person from engaging in 3 or more activities of daily living. So it's a pretty small set of people that you can take care of. Under the Connecticut FMLA as amended effective January 1st, and under the Connecticut Paid Leave Act, an employee will be able to take leave and receive benefits to care for a parent or spouse, or a son or daughter of any age, or a sibling or grandparent or grandchild, or an individual related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of one of these family relationships. Let me just pause there for a second. So, son or daughter of any age, sibling, grandparent, grandchild have all been things you haven't been able to take leave for before, but will be able to do in January. And then we've got this relationship by blood or affinity, which is usually referred to as simply the affinity relationship. This is recognition that families come in all shapes and sizes. It's a relatively new concept to Connecticut, but the federal government has been using it for decades, and some other states have used it. Some other large municipalities across the country have used it. And really, as I said, it's sort of a recognition that, the people you grew up with may not be the people who you consider to be your family right now. Maybe you have different people in your life who are as close to you as a family member, perhaps closer than your biological family. The definition or determination is really situation specific, and it's governed by the particular circumstances of you or your coworker. The employer can ask the employee to provide a simple written statement explaining how the person they want to take caregiver leave is the equivalent of a family member. And so if you are looking to take leave under this sort of related by affinity definition, you should expect that you may have to do that simple written statement. They cannot require you to have it notarized. They cannot require you to provide, photo albums and family videos or anything of the sort. But there is a need to make sure that, yes, this is truly a family member. And so we've got lots of examples if you think about it. It could be a aunt or an uncle who came to every family event, went to all the school concerts, and who relies on you for care. In my family, my great aunt didn't drive. And so we did her grocery shopping for years. And when she got older, we did her laundry and took her to the doctor. And when she broke her hip, we were the ones who took care of her. And she was the one who came to every school play and dinner and, would tell the family stories because my grandmother wasn't alive. So she took the place of my grandmother. She was the equivalent of my grandmother. The other one that is surprising to a lot of people is sort of this unmarried significant other relationship. Connecticut doesn't recognize common law marriages. So if you don't have a marriage certificate or a marriage license, Connecticut doesn't recognize you as a spouse. And up until now, if your significant other was sick, you wouldn't be able to take FMLA for them. Think of Goldie Hawn and Kurt Russell, right? They've been together forever, raised a family together, not married. Well, now under the new Connecticut FMLA, Kurt could take time to care for Goldie and get income replacement benefits if they lived in Connecticut. Okay, so we've got some good definitions here. Hopefully you understand the reasons you can take leave and apply for benefits. So what do you need to know? Like, how does this affect you directly? Well, the first thing you need to know is, do I work for a covered employer as defined by the Connecticut Paid Leave? Chances are most likely yes, because almost all employers who have one or more people working for them, working here in Connecticut, are covered. There are some exceptions. The state of Connecticut, for example, is only a covered employer as to its non-union employees. So managers, appointed officials, legislators, judges, we all contribute to the program and are covered. But we're not a covered employee as to our unionized population. They'll only be covered if they bargain to participate. Who else is not covered? Well, the federal government. So if you work for the federal government, you're covered under their federal laws and not the state laws. Municipalities and local or regional boards of education are excluded by law, so they're not participating unless their unionized employees collectively bargain to participate. And if that happens, then everybody, union and non-union, comes into the program. Non-public elementary and secondary schools are excluded from the program as well. Railroads are subject to a federal law, the Amtrak Act, and some other federal laws, so railroad workers do not participate in our program. Similarly, governments of other states, as well as the sovereign nations, so the Mashantuckets and the Mohegan, are not subject to Connecticut law, and so they are not considered a covered employer as well. There's a couple of exceptions just to flag for you. If you're an interstate truck driver who works in Connecticut but lives in another state, you don't pay income tax in Connecticut. And even though we call our contribution, it's technically a form of income tax. So these interstate truck drivers are exempted from that, and so don't participate. Similarly, a spouse of an active duty member who's moves to Connecticut because their spouse is deployed here, but has opted to continue paying taxes in their home state instead of here. Since they're not paying taxes here, they wouldn't be participating in our program, so they're not covered either. Finally, as a separate note, sole proprietors and self-employed individuals are not employees. They're sole proprietors or self-employed. So they don't have to participate, but they can choose to opt in if they want to. If they opt in, they have to remain in the program for at least 3 years. And they have to contribute, but they're contributing based on their self-employment earnings. Because they're not wage earners, they don't contribute out of wages. We know that there are lots of sole proprietors who have employees themselves, so they own their own business as a sole prop. Their employees work for that business, have to be enrolled, and then that owner can choose to be enrolled. So, do I work for a covered employer? If the answer to the question is yes, the next question is, am I personally eligible under Connecticut Paid Leave? Did I earn at least $2,325 in my highest earning quarter when you look at the first 4 of the 5 most recently completed quarters? At least that's what we're going to be looking at. And we know that lots of people have multiple jobs, either multiple jobs at the same time or they've switched jobs. And we are going to look at their earnings from all of those employers in that time frame. We do have access to data from Department of Labor, Department of Revenue Services, so we can help verify that they earn the $2,325. To be eligible, you also have to say yes to one of the 3 following questions. Am I currently working in Connecticut for a covered employer? Or was I employed by a covered employer in the 12 weeks immediately before I applied for benefits? So you could have been recently unemployed, or maybe you're a seasonal worker and your season just ended. But as long as you apply within the 12 weeks after your employment ended, you can say yes. Or finally, you're one of those sole proprietors or self-employed individuals who opted in. All right, so I work for a covered employer. I'm personally eligible. So what do I get? Well, you get income replacement benefits. The amount is based on how much your base weekly earnings are. And we determine your base weekly earnings by looking at your highest 2 quarters of the first 4 of the 5 most recently completed quarters. Divide that by 26. If that base weekly earning is less than or equal to the minimum wage times 40, your benefit will be 95% of those base weekly earnings. If your base weekly earnings are more than the minimum wage times 40, it's a 2-step process. It's 95% of 40 times the Connecticut minimum wage, plus 60% of the difference between the base weekly earnings and the Connecticut minimum wage times 40. In all circumstances, the total benefit is capped at 60 times the Connecticut minimum wage. So just like the contributions are capped, so too are the benefits capped. Now, I don't know about you, but hearing someone kind of describe in third person a math problem is not all that helpful to me personally. But good news, you don't have to pull out your pen and paper or your phone to figure that out yourself. You can go to our website and look at the benefits estimator we have on our website. It is truly an estimator. There are lots of factors that go into how much your benefits are, including, did you properly calculate your highest 2 earning quarters from the first 4 of the 5 most recently completed quarters? Are you going to be out for a full week or less than a week? Is your employer going to be providing any benefits to you? But this is a good estimate, right? It gives you kind of something to think about and plan from. And so you can see, do I fit into that 95 number? Do I fit into the 95 plus 60? Or am I in the world where my benefits would be capped? What else do you need to know? Well, you need to know if your employer is going to be providing you with any income replacement benefits while you're out on a covered leave. The Connecticut FMLA says that the employer can require or permit you to use your employer-provided time off while out on leave. Now, there is a new provision to that which says the employer cannot require you to exhaust all of your PTO while you're out on FMLA. You have to be allowed to hold at least 2 weeks of your time in reserve for another reason. So, is your employer going to require you to use your PTO except for those 2 weeks? Or are they going to allow you to use it? If either way, are there rules? Maybe you have vacation and sick leave. Can you use sick leave for something not your own serious health condition? Can you use vacation without having to bid on it? What are the rules? And if your employer offers short-term disability insurance, you need to know what that policy says. Does that policy say that you have to exhaust your PTO and the state benefits before you can access the insurance benefits? Does that policy say it's the payer of last resort? or is it going to pay upfront? The reason you need to know these is because there's basically 4 buckets you could land in. If you have no PTO or you're not required to use it and you go out on leave and you're eligible, we're going to award you your CTPL benefits, and it'll cover the full amount of time that you're out on leave. On the other hand, if your employer says, hey, we give you unlimited sick time, we want you to use that sick time, maybe you've got plenty of PTO to cover the leave, you're getting your full income replacement through your employer, you would not get CTPL benefits from us, at least not right now. Your CTPL benefit would remain intact, untouched, unless you need it in the future. And the reason for that is our statute says an employee can receive benefits from both the employer and the paid leave authority at the same time, provided the total amount doesn't exceed 100% of their regular wages. So if you're getting 100% from your employer, you wouldn't get anything from us yet, but your 12 weeks still remains available. What happens more often, I think, is that you might have enough PTO to cover part of your leave. Maybe you've got 4 weeks of PTO and you're going to be out for 2 months, and you've got the right to keep 2 weeks in reserve in case you want to use it for something more fun than being sick in the future. So you would use those first 2 weeks that your employer requires, and then you would start getting benefits after you've exhausted that time. And finally, you may have situations where the employer's PTO is less than your regular pay. So you could get benefits from the authority and the employer at the same time. If that's the case, we just need to know what those policies are. Is your employer paying first, or are they simply going to top off the benefit you get from us? We have a form that you would give to your employer that asks that very question. All right. How much money I will get? How long will I get it? Well, I referenced 12 weeks. The basic rule is you get 12 weeks of income replacement benefits in a 12-month period for all the leave reasons I mentioned, with 2 exceptions. First, because family violence leave is only 12 days, you'd only get income replacement benefits for those 12 days. And second, there's a provision in the statute that says an employee may receive an additional 2 weeks of CTPL benefits for a serious health condition resulting in incapacitation during pregnancy. Because of the way serious health condition and incapacitation, as well as pregnancy for that matter, are defined, this means that a person who is pregnant who needs to go to prenatal visits that they can't schedule around work could take FMLA for those absences and could receive CTPL benefits for that unpaid time off from work. Or maybe it's a complicated pregnancy. They're having complications. They need to go on bed rest. They could use these 2 weeks in addition to the other 12 toward that. Or finally, maybe they're pregnant and they break their leg. They have some other situation where they themselves have a secondary serious health condition. They could access these 2 weeks. And you'd use these 2 weeks first and then get their regular 12. Okay. So I've told you all about what you could get. How do you get it? Well, you've got lots of ways of doing that. As I mentioned, we started accepting applications last week. The fastest and easiest way is to apply through our online portal, but we can also accept applications through mail, email, fax, or telephone. If you go to our portal, you go to ctpaidleave.org, you click on the process, and then the first button is claims. And we walk you through the entire process of, first you have to create an account so we can credential you, so it's a secure account, because that's where you're going to be uploading your medical information and your identity verification information. You want it to be secure. And then you're going to tell us what your reasons are, give us the documentation, and go forward. The second easiest way is to call our third-party administrator. We've contracted with AFLAC to handle this for us, and they can do that whole process through by phone. And then there's also a possibility of uploading documents through email or faxing or regular US mail. It is a statutory requirement that you notify your employer that you're applying for benefits through us. Your employer doesn't have the right to tell you not to, but you have the obligation to notify them that you're doing it. As I said, you submit the claim, you'll tell us the reason, we'll validate that you're eligible, and Aflac will be doing that for us using data from Department of Labor and other documentation. They'll review the documentation you provide, including that employment verification form that I mentioned, as well as the medical certification, if applicable, to determine if your reason meets one of those reasons that I described. And if it does, we'll approve the claim and tell you that you're going to be awarded particular benefits using that calculation that I described and taking into consideration the offsets for other income. We issue the payments either through direct deposit, so electronic transfer, or debit cards. Stored value cards is the phrase they use. If we do it through the debit, we send you the card and then you get an upload every week. The benefits are issued on a weekly basis. Right now, they'll be paid on Tuesdays. And we're paying them, it says here 2 weeks in arrears. Really, it's 10 days. So if you're out that first week of January, the week that ends on January 8th, the benefits will be issued the Tuesday, the 18th. The reason we need that extra week is because a person who's receiving Social Security disability insurance, workers' compensation benefits, or unemployment insurance cannot also receive benefits from the Paid Leave Authority. It's a statutory bar. And so even once we make sure that your reason counts and all of that squared away, we need to do that final check to make sure that you're not getting benefits from one of those other sources. We will ask you to keep us informed over the course of your time off from work. If your leave changes, if you end up getting benefits from another source that you haven't told us about, or if you're taking intermittent leave, which is leave for one leave reason, but your absence is in small chunks of time, possibly not even scheduled, and so you don't know in advance exactly what day you're going to be out. We do need you to tell us when you're out. All right. Hopefully that gives you a good framework for CTPL. Let's just talk briefly about FMLA before I go to questions. Family Medical Leave Act. Remember, there's two of them. So the first question is, do I work for a covered employer? For federal FMLA, a covered employer is an employer who has 50 or more employees, or a governmental entity of any size, including the federal government, state agencies, towns, and schools, public and private. Actually, private schools have to have 50 or more employees. Public schools can be any size. Under Connecticut FMLA, under the new law that will take effect in January, it's going to be extended to, again, almost all employers who have one or more employees working in Connecticut. This does include the state of Connecticut as to all of our state employees, but it does not include employees of the federal government, municipalities, boards of education, non-public schools, railroads, governments of other states, or the sovereign nations. So you may work for one of those entities, and they may have adopted a policy, that looks like FMLA, but it's not technically FMLA, or more likely, you're just covered under federal FMLA. Am I eligible for leave? Well, under federal FMLA, you have to show that you were employed by your employer for at least 12 months, and that you worked at least 1,250 hours in the 12 months immediately before you go out of work. The old Connecticut FMLA was similar to that, but under the new Connecticut FMLA, starting in January, all you have to do to be eligible for job protected leave is show that you were employed by your employer for at least the 3 months immediately preceding the leave. That's it. There's no hours worked requirement. What do you get? Well, under federal FMLA, it's 12 weeks of leave in a 12-month period, except for that 26 for military caregiver. Under Connecticut FMLA, it's 12 weeks of leave in a 12-month period. This is new. It used to be 16 weeks of leave in a 2-year period, but starting in January, it's 12 weeks. But you get 26 weeks for military caregiver, and Connecticut FMLA also has that 2 extra weeks for incapacity during pregnancy. And then, as I mentioned, for Connecticut Family Violence Leave Act, it's just the 12 days. Sorry, before I move on. If you are eligible for both Connecticut and federal FMLA, and your employer is covered by both Connecticut and federal FMLA, and the reason is covered by both federal and Connecticut FMLA, you're going to be drawing your Connecticut and federal FMLA at the same time, right? So it's not 12 weeks plus 12 weeks, it's 12 weeks and it's from both buckets, just so you know and you're not surprised. All right, how do you apply for FMLA? Well, you apply through your employer. Paid leave has no authority, the Paid Leave Authority has no involvement in the FMLA process. This is directly between you and your employer. You need to tell your employer you need time off from work. Technically, you don't need to tell them it's FMLA, but you need to give them enough information so that they know, oh, it's for one of these qualifying reasons. So using the phrase FMLA makes life easier for everybody. You need to tell them 30 days in advance if the need for leave is foreseeable, and as soon as practicable if the need for leave is not foreseeable. So if you were hit by a bus, you don't have to call them from the ambulance, but you do need to call them pretty soon. You don't want to wait. They need to know where you are. Once you tell them, they have 5 business days to tell you if you're eligible for Connecticut FMLA, federal FMLA, family violence leave, or any other laws that may apply, and to tell you if you need to provide them with any additional documentation. They're supposed to give you something called a Notice of Rights and Responsibilities, which the Connecticut Department of Labor is updating to meet the new statutory requirements. This is not leave approval. This is just a, hey, you're eligible, and now we need to see if your reason for leave qualifies. Then you have to give them the documentation they ask for. If it's your own serious health condition, they're most likely going to ask for a medical certification. If it's bonding for adoption, you may have to provide the adoption documents. If it's qualifying exigency, there's some documents about the military records. They have to give you at least 15 calendar days. You don't have to wait 15 days to give it to them, but they have to give you that time. And if you're having trouble getting the documents together, tell your employer. If you let them know within that 15 days, they'll give you additional time. They're required to. Once you give them the documentation, they have 5 business days to review it and to tell you if anything's missing. And if it's missing, they have to tell you what's missing, to deny it and explain to you why it was denied. Not a covered reason, you've already used up your entitlement, things like that, or to approve it. And if they approve it, that's when they have to tell you officially, okay, you're going to use your paid leave accruals or not, or you have 10 days, you can choose to use them. If you need to report in, they have the right to ask you to report in. If it's your own serious health condition, they may ask you to provide a fitness for duty before you return to work. When you actually go out on leave, or if it's intermittent leave, those days that you're going out on leave, you have to call in and say, hey, this is my FMLA. Or I know I thought I was due at the end of the month, but I'm in labor now. Don't just ghost them, tell them, because that's how they know to start your job protection. And they're going to be tracking your usage so that you know, and they know how much time you're using, so you don't inadvertently use up more time than you're entitled to and lose the job protection. And then the whole ball of wax here is that you get job protection. They cannot penalize you for the time off. They cannot count it against you on your employment evaluations, and they have to return you to the job you had before you left under the same terms and conditions. If you're out for your own serious health condition, maybe you have some medical restrictions on your way back. You can't lift more than 20 pounds, can't work overtime for a couple of weeks until you get stronger. That's not an FMLA issue. That's actually something that would be assessed under the Americans with Disabilities Act, the Connecticut Fair Employment Practices Act. But just raise it here because it's important for you to know that these other laws exist and that you should have a conversation with your employer that says, my doctor says I can come back to work, but they have to work with you on that. Remember, even when you're approved for Connecticut or federal FMLA, you do have to follow your employer's attendance and call-in policies. And you need to notify your supervisors when you're taking your time. It's your responsibility to provide the employer and, frankly, the authority with the complete and sufficient medical documentation and other documents that are required. Practically speaking, you're going to give the med cert to your doctor, and most likely they're going to fax it to your employer, just like they'll fax it to us. You're sort of responsible for making sure they get it to us. as I mentioned, there may be some other laws that apply to your situation. So Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act are all things that you should be aware of. And finally, we do see this sometimes where people say, I want to save my FMLA. Don't call this FMLA. I want to save it for that knee surgery I'm going to have later. That's not a thing you can do. In all circumstances, it's the employer's right and responsibility to designate time off that qualifies under Connecticut or federal FMLA as FMLA. They're doing this to protect you and to protect themselves, right? You need to know that it's FMLA. You need to know you have the job protection. They need to know that you know what your responsibilities are. And they have a right to say, no, you get 12 weeks. We're going to count this. Giving you a lot of information. And as I said, we will share the slide deck with you. But if you have questions that we don't get a chance to address today, or if you think of them later, check out our website, ctpaidleave.org. We've got videos, we've got frequently asked questions, we've got toolkits. We've got it sort of set up for like employees, employers, sole proprietors. The whole thing's open. There's no special secrets anywhere. You may be interested in the guides we give to the employers. A lot of what we give to the employers are things that we think the employers may want to give to workers. So look at it all. If you can't find your answers through our FAQs or the guides, you can contact us. There's a button on our website. It's called Contact Us. You submit your question and you can identify if you want a call back or an email back, and we'll get back to you. One note about that, we know some people, spam filters block getting responses. So if you wrote to us and you didn't hear anything, check your spam folder because it's most likely got caught up there. All right, I'm going to stop sharing. I see at least one question came in. Wow, great question. If a worker is currently out on FMLA and is not expected to return until February, can they apply for CTPL now? Yes, please do. That's why we opened early. And you can go to, as I said, ctpaidleave.org and click on the how to file a claim. And you'll let us know, okay, I'm out now, but I'm going to be out through the month of January, and we'll get you started. The benefits won't start and won't cover until January. So we can't give you any benefits for the time now, but we can give you benefits if you're eligible for the period of time after January 1st that you're out of work and not receiving income from your employer. So please go ahead and get that filed. That'll simplify your life a little bit in the future. All right, I'll give people another minute in case anyone has any other questions they want to ask right now. I'm trying to think if I forgot to say anything. Really, the big message is check out ctpaidleave.org. And, frankly, we'd appreciate it if you talk about us. Let your family members know, let your friends know. This is a Connecticut program. You don't have to live in Connecticut to be eligible, but you do have to work here in Connecticut. So if you've got friends working in Rhode Island or Massachusetts or New York, they need to look up their own state's programs. Everybody around us does have a paid leave program, literally. New York, Massachusetts, Rhode Island, New Jersey, all have their own paid leave programs. But if you work here in Connecticut or you have a family member or friends who work here in Connecticut who you think may value this information, please share it. Let them know. Oops, looks like one more question has come in. Do you have a site we can review the PowerPoint from? So our website is ctpaidleave.org. And if you go to the website, there's the events calendar. And we actually post the video and the PowerPoint sort of on the day. It'll take us a couple of days to get this posted, but it's available there, or you can check out previous webinars, or we're going to send it to you. Another great question, if a worker exhausts their FMLA and their employment is terminated, can they continue to receive income replacement benefits? Yes. So if you remember back to that slide about eligibility under FMLA is different than eligibility under Connecticut Paid Leave. And that was deliberate. So a person who is eligible for Connecticut paid leave can get the income replacement benefits, even if they're not eligible for job protection under FMLA, or even if they've exhausted it. So, you may have a situation where you've been working for covered employers, so you've been contributing into the paid leave program and you've earned your 23.25, but you've changed jobs. And so you haven't worked for your new employer for 3 months when you need to take your leave. They may not hold the job for you. I mean, that's unfortunate, but that's the reality. But you could still apply to us for benefits. Or you could be in a situation where, your job protected leave ended on January 5th. And so you're sort of out of luck in terms of job protection, but the benefits are still going to be available if you're eligible. Remember, the person who is currently unemployed has to show that they were employed at least some point in time in the 12 weeks before they apply. Okay. We'll just wait another minute in case any other questions come in. But ctpaidleave.org is the place to go. And you can also go to YouTube. I forgot about that. We do have a lot of our videos posted on YouTube. So if you go to YouTube and look up CT Paid Leave, you can see a lot of our videos. We've got webinars for workers, for HR, for employers. If you're having trouble sleeping some night, you can just put us on and we can lull you off to sleep. But there's a lot of information out there. I do appreciate the fact that you gave me some time this morning. I hope that this was useful to you and gives you some information that you can use. Which, as I said, please feel free to share with others. If you think of questions in the future, or you're think of, I meant to ask, or Erin terminated the webinar just a minute too soon, please don't hesitate to use that contact us, and we will be happy to get back to you. But I think that questions are not coming in, and it looks like some folks are leaving, so I'm going to go ahead and close out the webinar. And thank you again. Have a good day, everyone.